Normally, you will not defy a directive that is coming from a higher authority. But we are in a constitutional democracy where our constitution states that we are established as a sovereign, secular, democratic, and unitary state founded upon the principles of democracy, the rule of law, and justice for all. Therefore, if the directive can pass the test of legality, then that is fine. You cannot defy it. But if it cannot pass the test of legality, then obviously some people might opt not to actually adhere to the directive.
Well, delegates went ahead with the General Assembly as planned, and they have acknowledged that, yes, the directive came from the minister, yet they feel that she was or is wrong. What does that say about the relationship between the minister and the youth body?
The relationship, based on what you have asked, seem not to be sound because subordinate institutions are supposed to adhere to the guidance and directive of a minister. But in this case, there are contestations about that directive. Hence, maybe the reason for proceeding. But also the timing. What we are reading in the newspaper, we have seen, is that directive was issued on Friday, the 13th of December, meaning some of those delegates were on the road or they have already arrived. The timing is not correct. Whatever the reason it is, the timing is basically just not correct. Because even if they have cancelled it, the resources of the state, of the public, have already been wasted. But obviously there seems to be not a sound relationship between the parties.
Now, the minister, after dissolving the board with immediate effect, after that, some say that the youth wing was not given a chance to defend itself. But on what grounds can one terminate or remove a board summarily?
Like I explained, we are in a constitutional democracy, meaning we are a state that is governed by law. You cannot make decisions that are arbitrary. In this case, in terms of the National Youth Council Act, Act number 3 of 2009, the minister can suspend the board members, or she can even remove them on her own initiative or on the recommendation of the representative council. So there's nothing wrong with removal. The issue is just whether it is legal or not. And obviously, what we are reading, it can be contested that it might not have been legal, but we'll hear further when those issues are dealt with. But the other principle in law, although I'm not a lawyer, is what is called the audi alteram partem. In other words, the other party must be heard before you make a decision that has a diverse effect, that has a negative effect on the party. Therefore, you cannot remove without hearing the other side of that party. The minister might say she have requested them to state their case, but basically I don't think they were properly heard. And it's a principle in law to hear the other side before you make a decision that has a negative impact on the other parties.
So talking about legality, obviously the NYC has taken the matter to court. where its lawyer demanded the reinstatement of the board, and they gave the minister an ultimatum of December the 15th. How do you see this panning out?
So we have to wait and see what the court will say. But I think also as a matter of principle, in terms of our constitution, anyone who is aggrieved by a decision of a body or an official can seek redress to a competent court of law or tribunal. I think we don't have a problem with that. So if a party is going to court, these issues of the other party to be heard and whether the decision will meet the requirements of both the Namibian Constitution as well as the National Youth Council in terms of removing a board and also the other party to be heard. These are the matters that we look at. But I always argue that we must not always go to court because there are cost implications. In this case, both the Honorable Minister and the National Youth Council, being a statutory body that is funded by the public have to pay for these costs, for the lawyers to go to court, a matter that we should have avoided. Also, the Honorable Minister, you have an Attorney General in government who is the legal advisor to the President and to the government. So these legal issues that we are talking about should have been cleared by the Attorney General before the removal, assuming maybe the Attorney General was consulted. But the point that I'm trying to make is it's a cost that the public is supposed to pay, and it's not the individuals that are involved that will pay. Do we really want to waste public resources on matters that you are supposed to resolve internally by going to court while public resources should have been used for other purposes?